Fourth case on docket this morning is 23-20034, BPX Production Company versus certain underwriters at Lloyd's. Mr. Sullivan.
Thank you, Your Honor. May it please the court, counsel. The important issue presented by this appeal is what option is available to a plaintiff who has a serious property damage claim against a bankrupt, insolvent, or judgment-proof defendant when the defendant's liability insurer has denied coverage and is not willing to participate in the process. In this situation, BPX elected to follow the procedure outlined by the Supreme Court of Texas in Hamel and endorsed by the Texas Court of Appeals in Landmark and recognized by this court in Turner. And that was to take an assignment of the coverage claims from BJ Services and then assert a direct action against BJ Services insurers. And in that lawsuit, establish both liability on the underlying claim, which was the damage to the well where the defective cement job had taken place, and then that claim was covered by the policies issued by Underwriters. This lawsuit was filed, and the parties consented to proceed before Magistrate Edison in the Southern District. Underwriters filed a motion for summary judgment alleging essentially two grounds for dismissal. First, that the duty to defend had not been triggered because there was no suit as required by the policy form. And second, that because the duty to defend had not been triggered, that there would be no duty to indemnify. Judge Edison determined that a suit had been filed because the dispute resolution provision in the master service agreement between BP and BJ Services contained a pre-suit requirement that BP submit a claim letter to BJ Services setting forth the basis of the claim, and that then there would be a settlement meeting. The magistrate found that was sufficient to trigger a suit, but then found that because in the complaint, BPX did not allege that BJ Services had obtained Underwriters' consent, that the duty to defend had never been triggered. The magistrate went on to find that because there would never be a duty to defend, there would likewise be no duty to indemnify, and therefore the process under Hamel was not applicable in this situation.
Okay, well, I realize I don't do as much insurance now as I did in the past, but I'm board certified in consumer and commercial law. I'm well aware of Texas insurance law. And the notion that duty to defend and duty to indemnify are the same thing is completely ridiculous. And it is not true that the duty to indemnify is always related to the duty to defend. Once in a while it could be, but usually not, because you don't know what they're going to prove, and what they prove might be different. So I totally agree with that notion that the two are not connected. But here, well, they're connected but not fully connected. There is some relevance, but that, there were plenty of times that the Texas courts would say, you have to hold the duty to indemnify until after the underlying trial, because we can't decide that. We can decide the duty to defend. That happens constantly. So I get all that, but let me get to what my concern is. Turning to the duty to indemnify, why isn't what the magistrate judge said that y'all never filed in the bankruptcy court and therefore would have no case against BPX, or against the, let's see, what was their name?
BJ Services.
Yeah. BJ, I was thinking BPX, BJ. The BJ, you would not be able to get anything from them because you didn't file in the bankruptcy. And so therefore, how is there a duty to indemnify? I know y'all reached a settlement, but it's a settlement. Let's you and I agree that Chief Judge Richman has to pay. Well, that's an easy agreement. That doesn't bind her. So I don't see how the failure to file something in the bankruptcy court isn't determinative of the duty to indemnify.
Well, Your Honor, BPX was not required to pursue a claim in the bankruptcy court. The BPX had the ability to pursue this in state court because this is a state law claim applying state law insurance coverage. So there's no requirement.
No, you can't recover from BJ when you're in bankruptcy court without suing BJ. And the insurance company owes money for their insured. This isn't Louisiana where you can just sue the insurance company directly.
Well, Your Honor, there's a Fifth Circuit case, Matter of Edgeworth, which recognizes that the insurance carrier does not get the benefit of the bankrupt's discharge. And so we had a bankrupt BJ Services. Filing a lawsuit against BJ Services would have been of no worth because their liability was discharged in bankruptcy. So the only way for BPX to pursue this claim was to take an assignment from the bankrupt defendant, BJ Services, and then bring the direct action against.
No, but if you never had a claim, I mean, I understand the notion that, let's say that this settlement thing had not been part of the deal. BPX sued BJ, and then BJ filed bankruptcy. Then the state court case would be put aside, and they would have to go to the bankruptcy court and file. And then the bankruptcy court could send it back to state court to litigate it for purposes of the insurance. That happens all the time. But it is necessary for it to have been filed in the bankruptcy. If they, let's say bankruptcy was filed immediately as soon as all this problem happened, they still would need to file. And then if it's discharged because BJ doesn't have any money, then I agree, they can go to the insurance company, but they still have to have been able to recover from them. And they can't if they don't sue in the bankruptcy. I mean, that's something the magistrate judge explicitly said that made sense to me. So please explain.
Well, respectfully, Your Honor, I don't believe that BPX had to pursue it in the bankruptcy and then have the bankruptcy court say, there's no money here for you because the assets of BJ Services are insufficient. Consequently, you have to pursue it.
Well, normally that's a claim that has value. And it would go to, it would be dealt with under the plan of confirmation. And assignment could all be part of the plan of confirmation, and then it could proceed. But normally that's an asset. That's considered a money asset. And it's handled in the course of the bankruptcy.
Well, to your point, Judge Richman, I agree, but the coverage itself was not what was going to be used to finance or otherwise impact BJ coming out of bankruptcy. BJ's bankruptcy, as I understand it, was a prepackaged Chapter 11 where they had negotiated all of the terms and conditions with their lenders. This claim that BPX was asserting was just a general unsecured claim.
Right.
That would not have
It's still
been
part of the bankruptcy estate.
It could have been, yes, Your Honor.
It was. Not could have been, it was. I mean, it seems to me.
Well, I can't change the fact that BPX did not file a claim in the bankruptcy. BPX did obtain an order from Judge Isker approving the transfer or the assignment of the coverage claims that BJ Services had against its insurers and allowing BPX to pursue that claim directly against the insurers.
Okay.
So when it was presented to Judge Isker after the fact, he did not apparently bring up the idea that it should have been litigated in the bankruptcy.
No, I mean, he said you can't get anything from BPX. But, I mean, there again, I can see the judge thinking, well, if the insurance company will pay, I ain't going to stop them. I mean, that's just not really part of my concern here because that can't go into the general bankruptcy bucket because it's specific to this. So I can see how the bankruptcy judge wouldn't mind that, but that is different, again, from whether that's proper under duty to indemnify.
Respectfully, Your Honor, this case was not dismissed on the basis that BPX didn't pursue the claim in bankruptcy. That was not what was...
The magistrate judge mentioned it, though.
He mentioned it, but he did not make that a dispositive finding.
That's important in that finding.
Well, and my interpretation of his order was that he determined that once BPX did not allege Underwriters' consent to the ADR procedure, that was dispositive of the entire case. So I've studied the order, and
There are matters before the district court that can affirm something,
What?
even if they didn't rely in full on it. The magistrate judge mentions this.
I-
So even if we disagree that duty to indemnify is based on duty to defend in every case, period, end of story, we could affirm on that ground. And that's on the duty to indemnify. So that's why I was asking about it.
Well,
But
you-
if you've answered, then I have another question.
well, I will just follow up that I think that the bankruptcy court would have been within its power to abstain from even hearing the claim if BPX had decided it wanted to pursue the claim in bankruptcy court. It's a state law claim. It's a state law issue. The bankruptcy court could have very easily voluntarily abstained and said, this is a state law action. I'm going to send you to state court. So
The way they do that is they say, go to state court, litigate this, then bring it back. Because the thing is, if what you're litigating is BPX versus BJ, they can send it, they can have a trial and all of that. But BJ isn't going to owe the judgment. Let's say a huge judgment is assessed. They can't owe that judgment until we come back to the bankruptcy court, and then the bankruptcy court decides what to do with that. And they can say, well, you were awarded $1 million, we're going to give you $10. And that's how that works. So,
Your Honor, in my experience, that's not how it works. In my experience, and I've had these cases, is that the insurance assets do not get the benefit of the discharge. And so,
no, I get that, but what I'm still talking about suing. BPX is still the one that is suing, and BJ is the one that supposedly did wrong. Underwriters is only involved if BJ did wrong. That's what would be tried. And a lot of times, like I said, they send it back to the state court to decide if that entity is liable, and then it would be paid by the insurance company. That's fine. And the $10 that I talked about might be all that the insured had, but not what the insurer has. So I get all of that. But let me go back to the duty to defend. I have one question on the duty to defend. Let's assume arguendo that there was a duty to defend. What do you recover for that?
I think we recover the amount that BJ Services expended defending against BPX's claims from the time of the denial up until BJ filed bankruptcy.
And what was that? Because you never sued it.
It had not been quantified. We had not had the opportunity to do discovery on that. So I think that there was some amount of money that BJ Services would have expended to deal with the pre-suit dispute resolution procedure.
Okay, on the duty to indemnify piece and damages, how did you comply with Hamel?
Pardon me?
How did you comply with Hamel?
We complied with Hamel by taking an assignment from BJ Services and then pursuing the action directly against Underwriters, as Hamel says we're required to do.
Okay, the other thing on duty to defend, I may have missed it, but it seemed to me that the focus was just on whether the underwriters consented to this settlement discussion and so on and so forth, not what does the insurance policy say about this. And so if we were to disagree with the district court's conclusion that the lack of consent to the settlement discussion was somehow determinative, wouldn't we need to remand it to look at whether there really is a duty to defend in the first instance?
I think if you were to reverse the magistrate, the remand would be on that we had established that a suit had been filed, and the magistrate judge went along with that by finding that this pre-suit dispute resolution procedure was a suit. And I think if the case were remanded, Underwriters who did not claim they were prejudiced in this motion to dismiss practice would have the ability, were they so inclined, to claim prejudice and then have that determined.
No, but what I'm saying is just because you say your insurance company has a duty to defend doesn't mean they do.
Well, Your Honor, I think that read in the light most favorable to the insured, which is supposed to take place under the Eight Corners Rule duty to defend, the claim letter from BPX to BJ Services says BP was damaged as a result of the negligence of BJ Services. So I think that's enough to trigger a duty to defend.
If it was that simple, I would have never had any work when I was a lawyer.
All right, thank you.
Good morning, Your Honors. Michael Carr for Underwriters.
Do you want to start with that? If we were to disagree with this finding about no consent for the settlement conference or whatever, wouldn't we need to remand on the duty to defend? Or do you agree that just because someone writes a letter to the insurance company, they owe a duty, or to the insured, that the insurance company owes a duty to defend?
And honestly, I think you would have to remand. This is a motion to dismiss. And so we were only at the pleading stages. So if this court were to disagree and find that there was the potential for a duty to defend, or more importantly, disagrees that the consent was a dispositive issue such that there is no duty to defend, such that the claim should be denied, then yes, the duty to defend claim would be remanded. Now, you can still affirm on the duty to indemnify, and I had planned to address these differently, but Judge Haynes, you had noted that the duty, just because there's no duty to defend, it doesn't mean there's no duty to indemnify. It's absolutely true under Texas law. The reason that matters here, and the reason the trial court dismissed the duty to indemnify, is not simply because there's no duty to defend, therefore no duty to indemnify. What he said was the Texas Supreme Court in Hamel premised the Hamel procedure, this new lawsuit where you get to sue the insurer directly, required a wrongful denial of the duty to defend. That was the linchpin. The court used, and I forget the exact phrase, but the court said it was a compelling reason. Absent that compelling reason, it wouldn't have allowed the duty to indemnify issue, wouldn't have allowed this Hamel fully adversarial second trial to occur. So if there's no duty,
I didn't read it that way, but go ahead. I mean, they said it was disconnected. It was disconnected. In other words, it was not dependent. And that even if you wrongfully refused to defend, that didn't mean that you got popped automatically for the indemnity. You were still entitled to an adversarial trial on the obligation to indemnify and the damages.
Yes, Your Honor. That's what all the Hamel case and all of the cases after
it seems to me say even if you had rightfully declined to defend, that does not necessarily resolve your duty to indemnify.
Normally, it wouldn't. Normally, in the normal situation, such as Judge Haynes had noted as how you would normally deal with this in bankruptcy, or if there was never a bankruptcy, just because an insurer doesn't have a duty to defend, the case still gets litigated, the jury still decides that if someone's at fault, they still award damages, then that insured, who has a judgment now against them for some dollar amount, can come back to the insurer and say, see, you denied the duty to defend, but the duty to defend is based on the 8 corners, the pleadings and the policy language. The duty to indemnify is based on what did the jury actually find? And that could trigger coverage for an indemnity obligation. And so, but that's not what we have here. In Hamel, what the court said is, the Texas Supreme Court said, the wrongful denial of the duty to defend is what gave them pause. That was otherwise they would never allow this secondary trial.
I don't see how that helps you here, but go ahead.
I'm sorry?
I don't see how that helps you here, but go ahead.
Because it's our position is what the trial court found that there was no duty to defend here.
But what if we disagree with that?
If you disagree with that, then you can still affirm on the duty to indemnify on a different reason, obviously.
Is it the reason that I said?
It's exactly the reason Your Honor said.
Can you explain it then? Because
yes.
Obviously my question didn't seem to make
so,
sense to your opponent, so please.
So normally what would happen in a situation like this, first of all, just to give a little bit of background, we're talking about a period of, the incident occurred October of 2018. BJ Services didn't file their bankruptcy petition until July 20th of 2020, almost 2 years later. It's 21 months. During that entire time, BPX could have filed a lawsuit against BJ Services before bankruptcy, could have proceeded in state court.
Because the timing for this settlement conference passed.
30 days.
Yeah. So
Correct.
You're saying that even if that was all proper, all handled right, and you all were wrong in not participating, that still had passed.
Correct. But if they hadn't, if BPX continued to do what they did here and instead waited case got filed in the bankruptcy court, as Your Honor pointed out, could have filed a notice of claim. What normally happens in those situations, and I've been involved in many, many of them in Texas, is the plaintiff will petition the bankruptcy court to lift the automatic stay and allow them to proceed directly against the debtor. As part of that order, normally what the court will say is, any judgment you get, you can't enforce against the debtor. But you can enforce it against the insurance company.
Yeah, but you can bring it back.
And you enforce it against just the insurance company. That's how it should have happened. It didn't happen. BPX slept on their rights for whatever reason, chose not to file a notice of claim, or maybe just didn't realize they should have filed a notice of claim. And then it was too late. And the only reason we're here is they're trying to resurrect something. But as Your Honor also pointed out, the duty to indemnify is just that, the duty to indemnify the insured. Any exposure that the insured had. Here, the insured has zero exposure. There's actually no judgment or settlement of any dollar amount against BJ Services, our insured. And what BPX wants to do is say, despite the fact that we have no judgment or settlement against your insured, you insured should pay more than $0. And every case that cited Hamel, there's 21 cases if you search Westlaw that cite Hamel. And of the few, because not all of them obviously cite it for this reason, in literally every case, you have a plaintiff who gets a judgment or a settlement for some dollar amount against an insured. They then go to the plaintiff then takes that judgment or settlement and says to the insurer, pay me this. And the insurer says, no, I'm collaterally attacking that judgment because it's not the result of a fully adversarial trial.
Well, all right, well, assuming we disagree with you up to that point, isn't what you really want an adversarial trial?
No, because we don't think that they're entitled to that.
Well, assuming we disagree with you. Because it doesn't seem there was ever an adversarial resolution of the claim against BJ Services.
But that's because BPX never just slept on its rights. There could have been. They had multiple avenues to do that, and they didn't. And it's not proper now to turn around.
Well, one avenue in the bankruptcy court was say, rather than go, we don't want to spend the money to go try it, and we're just going to assign this to a creditor, and the creditor can go then spend their money to bring a lawsuit. But then you've got a bankrupt.
The big difference between what Your Honor is proposing and what all the Hamel decision, the Hamel case and its progeny, and it starts with Gandy actually, which Hamel is based on, is in each instance, there wasn't just a assignment and go see what you can get from the insurer. There was always some judgment amount, $1 million, I think Your Honor uses the example, or $10 million. There was a judgment or a settlement.
All I hear Hamel saying is that the remedy here is that you have to have an adversary trial.
But the
It doesn't say that just because you assigned it and that there was no adversary trial, that's the end of it. It says you are entitled to an adversary trial.
But first of all, the person who's entitled to it in Hamel is the insurer. Because the insurer collaterally attacked a judgment or settlement. And the reason they did that is they said, well, and I forget the exact number, but I'm going to use the $1 million example. You insured agreed to $1 million judgment against you. And the reason you did is because they told you they weren't going to execute against you. They were only going to execute against the insurer. So you had no skin in the game, no fully adversarial trial. And then the plaintiff who has this $1 million judgment brings it to the insurer and says, insurer, I have $1 million judgment against your insured. Pay me $1 million. The insurer says, oh, no. The $1 million, we can't trust that. That wasn't part of a fully adversarial.
But you're saying you get to walk, that you're, because there's no dollar amount, you get to walk.
Because they never sued. It's the same way, Your Honor, as if the statute.
That's the problem that you're focusing on that is bothering me, is they never sued them even in filing a notice of claim in the bankruptcy court. And so what Chief Judge Richman is talking about is very important. Let's say there was just a lawsuit, and let's forget the bankruptcy, you filed in state court, and they were sent to mediation and settled. That's totally proper, and you can seek that from the insurance company, but the insurance company can then say, we want an adversarial trial. And that's all what Hamel's talking about. That's totally proper. But first there has to be some basis for that. And the problem that bothers me is there never was a lawsuit, and not just that, there never was a claim in bankruptcy court. And so what if they had waited 10 years to go after BJ? Well, the statute of limitations has passed. that doesn't mean that all of a sudden there has to be a whole adversarial trial. The insurance company doesn't owe it because the insured didn't owe it. And so the bottom line is, what does the insured owe? Not because they don't have any money in bankruptcy they can get out of it, but what do they owe? And I think that's a problem here because of BPX's failure to sue. But I could be wrong. I defer to my
I agree
Supreme
with
Court justice from the Texas Supreme Court, which
respectfully,
heard a lot of these cases.
and respectfully, I agree with you 100%, and I don't think you're wrong. That's the issue, and that was I was going to point out. If instead it's a negligence cause of action, which in Texas is a 2-year statute of limitations, if they waited till 2 years and 1 month, and they have a very
That's an
good
affirmative defense that you can raise. That's not a basis for a motion to dismiss on the face of the pleadings. Tell me what Judge Isger did from your standpoint. What did he do?
I'm sorry. Your Honor?
What did what did he do from your standpoint? He did something.
The judge in the bankruptcy court?
Yes.
And the bankruptcy court judge entered an agreement that BJ Services and BPX agreed to. And what BJ Services said is, BPX, you say we owe you something. You know what? Whatever we have against Underwriters here, you
We're
take it.
signing to you. Now, what's wrong with that?
There's nothing wrong with that.
So that they can
But
take that claim and now sue, which they've done in federal or state court as this assignees of the bankrupt's claim.
The
What's
reason
wrong
is
with that?
Because BPX only has what BJ Services would have had against us. BJ Services doesn't have any indemnity, doesn't have anything that they would have ever owed. So there's no indemnity.
Why not? We don't know because there's never been a trial.
Because BJ Services can never know. That's what the bankruptcy court order says.
No, it didn't. It said we're assigning this particular claim to somebody, and so we're taking it out of bankruptcy. It's no longer part of an asset of the estate. Go and do whatever you want with it. It's got whatever you think it's worth. You go pursue it. That doesn't mean that it doesn't extinguish the claim when you assign it.
No, absolutely. What I'm saying is that claim, again, they're relying solely on Hamill, which again is where all of this is coming from, the Texas Supreme Court.
And Hamill sees nothing wrong with taking an assigned claim and having an adversary trial. If the insurance company owed a duty to indemnify, then the assignee of that claim can pursue that claim against the insurer under Hamill's, the way I read Hamill.
And that's how I read it as well, Your Honor, except there's a very significant and important precursor to that. Again, putting aside the duty to defend issue, and we do think that the trial court was correct that there is no duty to defend here, and I can address that if the court would like. But on this issue of the duty to indemnify, in Hamill and in every case that relies on Hamill, it didn't happen like this. It didn't happen where we never got a judgment. We, BPX, never got a judgment against BJ Services. We, BPX, never got a settlement number from BJ Services. Instead,
They want that now. They want to.
They want it now, but
They're
now it's
making
too
a
late.
claim, and they want to try their claim against the insurance company in the shoes of the insured. What's wrong with that?
because it's too late.
It's not.
And the reason it's too late
That would be
is
a defense, though, right? When you say it's too late, I imagine an adversarial trial where you say, well, look, your claim is too late.
the reason it's too late is because
And you might win on that.
you still need to have, in Hamill, for Hamill to apply, BPX would have had to have gotten a judgment against BJ. So Hamill is about
No, it doesn't
insurers,
say that. It does not say that.
but that's what the facts are. And every case that
Well,
deals with Hamill-
that's not what it held. The big stumbling block here was that they had denied a duty to insure wrongfully. And normally, that's the end of the game. Up until Hamill, that was it. You do wrongful denial of defense, buddy, you're stuck. Whatever happens to you, you deserve. So Hamill was saying, wait a minute, we're backing up on that. Even if you wrongfully denied your duty to defend, we're not going to automatically stick you with whatever settlement the insured reaches with.
if there wasn't a fully adversarial trial, yes. But again,
So that means even the denial of the duty to defend was irrelevant. They're saying now you cannot get a judgment against the insurance company unless there's an adversarial trial, basically.
but
And I don't see how this assignment runs afoul of Hamill at all.
the assignment, the reason it does run afoul, Your Honors, it was in your question, because your question assumed there was some settlement that was against the insurer.
It doesn't assume a settlement. It's an assignment of what's the word in bankruptcy? It's just an assignment of a claim. It's just a straight-up assignment of a claim. It's not a settlement. it's not, doesn't purport to bind the insurance company. It just says, I get to sue instead of the insured. I'm just taking whatever claims the insured would have had, and now I'm going to bring them against the insurance company.
And I guess my response to you, Your Honor, is that the drastic result that Hamel itself notes is a drastic result, allowing this secondary trial that normally we don't allow to happen, was because the insurer collaterally attacked the judgment between the plaintiff and the insured. It's the insurer saying, we can't trust that number. And in every case,
You're saying,
since
there's no number, we don't ever get a number. I don't understand that logic.
The number is zero because BPX is owed nothing from BJ Services. They enter into an agreement, a settlement with BJ Services and say, you owe us nothing. Oh, but wait on, I want to now completely ignore that number I just agreed to and sue the insurer.
They don't say nothing. When was it ever determined?
Because it says there's no claim, and then it also says that you can't collect against this if there's no claim against this.
You have no claim against them. You can only sue the insurer.
Yes, but the issue, like again, and I feel like I'm not doing it justice, but Hamel in all of the cases is an insurer collaterally attacking a judgment. The insurers are not collaterally attacking a judgment. BPX is saying, well, we couldn't get anything against BJ Services because we just failed to act for almost 2 years. So now we're going to sue the insurer and see if we can fix
I guess it sounds like what we're arguing about is how this Hamel procedure applies to this maybe a unique situation. I'm not sure if it's a unique situation, but it arises out of bankruptcy. Can you point to anything other than sort of the fact patterns of the cases that subsequent to Hamel that can help you with this? Because I understand you're making a principled argument about this is a limitation on Hamel. I get that.
There's
anything?
So I'm not aware, Your Honor, of any case that actually details how Hamel is supposed to apply. What do we do once we're in this, aside from have the fully adversarial trial?
Yeah.
But it is, again, it's all premised on the insurer collaterally attacking.
I understand that's the principle you want, you believe is inherent in the proceeding. My understanding is, I guess what I hear the chief saying is that the premise of Hamel is there was a sham or possibly a sham settlement, and we're not going to stick the insurer with that. We're going to allow an adversarial proceeding so the insurer can say, no, actually that settlement was a sham and we don't really owe anything or we owe much less.
Yes, and the reason that there's the concern of the sham is we can't trust the number.
Right.
It wasn't fully adversarial. You had no reason to fight it. Because
Why can't we trust an assignment when there is no number? That's my bottom line question.
Right.
Let's take bankruptcy out of this. Let's say BJ's, they don't have the money to go sue. They don't want to invest. They factor it out. They say, pay us $5,000 of this claim, and we'll assign our interest to you, and you can go sue our insurance company, which there's no law against that. Factoring, whatever you want to call it, that's totally legitimate. It happens all the time. They come and sue. You don't have any defense to that lawsuit.
It's $5,000. It's what the insured would owe because it's a duty to.
No, it's not $5,000. That's what it's just a claim. It's just an assignment of a claim.
But the claim is the duty to indemnify. That's what's assigned. And what you're indemnifying as the insurer is the amount that the insured is obligated to pay. So in the case that Judge Duncan was noting
the insured saying, the insured said, I don't know what, I think they're obligated to pay me $5 million. I don't have the resources to pursue that. So I'm going to assign this to you for $10. You go and see what you can get for it. I'm done with that. But the other person says, this has some value. They pursue the assignment.
But in the way that you would handle that is the way that it was done in Hamel and the other cases is the insured would say, I owe you $5 million, settlement agreement. I owe you $5 million.
No, it doesn't say you have to do it that way at all.
It doesn't say you have to do it
Hamel's
because it's the way it was done in every single case that follows Hamel.
Are you saying there's no case along the lines that...
There is no case that has this kind of fact pattern that applied to Hamel.
And to me, the fact of the bankruptcy is relevant because the bankruptcy court said you didn't bring a claim, you don't have a claim. And so I do think that not having a claim against the insured is relevant to whether you can sue the insurance company.
I agree, but there's no fact pattern in any court that has applied Hamel and allowed...
If you don't have any possibility of a claim against the insured, then I don't see how we move here. if it was that the insurer doesn't want to try it and sends them off, what Chief Judge Richman is saying makes total sense to me. But this is a little different. They didn't file a notice of a claim. They didn't ever sue BJ, so they didn't have a right against them. So then BJ just awarding them a right that they didn't have is what that BJ wouldn't have had. BJ couldn't sue its insurance company because it didn't ever owe anything and never can. That's the thing that bothers me about this.
And it's what's bothered me throughout the case. But just to kind of highlight the last, there is, to answer your question about the best case, there is no case where a plaintiff doesn't sue an insured, doesn't get a settlement agreement with them, never, it just sleeps on their rights. And then for whatever reason, it could have been a business reason, that insured wants to do more work with this big party maybe in the future, says, you know what, if I had anything, it's all yours. And now that plaintiff is allowed to sue the insurer. It's HAML only applies, one, if you wrongfully deny the duty to defend, and I appreciate the amount of time, so I don't have time to address that. And then two, if there was some judgment or settlement for some amount against the insured that the insurer collaterally attacks. Thank you, Your Honors.
Maybe you can explain it.
Well, I don't know that I can explain it to your satisfaction, Judge Haynes, but I'll give it my best shot. The cases subsequent to HAML all seem to involve a situation where the claimant goes and has a sham trial, a not fully adversarial trial against the defendant, and then tries to collect it from the insurance company, and the insurance company says, no fully adversarial trial, King's X, I don't have to pay, back to square one. What we tried to do in this case is circumvent the need of having a useless trial against a bankrupt BJ Services, because if we'd have sued BJ Services and they'd have thrown up their hands and said, we don't have any money, we're not going to defend, we could have gotten as big a judgment as we wanted to. Once we tendered it to the insurers, they're going to say, no fully adversarial trial, we don't have to pay, and we're right back to where we are now. And so,
yeah, but if you never, I appreciate that, and I understand the whole sham issue, and there's been a lot of cases on that. But the piece that I don't get is if you don't have any ability to sue them, then I don't see how you can go to their insurance company. And having not filed the notice of the claim, having never sued in state court, not filing the notice of the claim, I don't see how there is a case that they can then assign. That's what they're assigning is your case against them. So BPX versus BJ gets assigned, BJ's piece gets assigned to their insurer. I get that. But if there's never that, if that never exists, there's nothing to assign. That's the piece that I'm having trouble with. Please explain it.
Well, the best that I can explain that is that the claim that was asserted under the alternative dispute resolution procedure in the master services agreement, that was the claim, that was the suit. Magistrate Edison found that demand letter, that claim letter, constituted a suit under this insurance policy. He said that the duty to defend was not triggered because Underwriters didn't consent to it. But he did find under the Florida case that we cited in the trial court that submitting a claim under a mandatory dispute resolution provision, procedure, and a contract constitutes a suit. So respectfully, there was a suit. There wasn't a formal complaint or a formal petition filed against BJ Services, but we did file a suit as that term is defined in the insurance policy, and respectfully, we think that's sufficient. One comment that was made is that the magistrate found that there would never be a wrongful refusal to defend because, in his view, the duty to defend had never been triggered. Well, on a 12B6 motion, all of our well-pled allegations are supposed to be accepted as true, and in our amended complaint, we allege a wrongful refusal to defend. And so that has to be taken as true for a 12B6 motion. So Magistrate Edison's statement in the order that there could never be a wrongful refusal to defend is just not accurate in 12B6 motion practice, because if you have to take all of our allegations as true, it's in our complaint that there was a wrongful refusal to defend, there was a wrongful refusal to indemnify, and I don't think that Magistrate Judge Edison can make that determination. I hate to say it was circular, but in a way it was. He says in his order, since I've determined that there was no duty to defend, there can never be a wrongful refusal to defend, and consequently, there can be no breach of the duty to indemnify because you never get there under Hamill. And kind of tagging on to, you had asked, one of you, I'm sorry, I missed which one, asked if there had been any subsequent practice under this. We cited a case, the Palmer Cravens case. We filed a supplemental brief last week, and in that case, the claimant filed suit against a bankrupt defendant. The bankrupt defendant's heirs disclaimed any interest in the lawsuit, which is what we contend would happen here. BJ Services there would be no obligation for them to defend because they were going to get a discharge. And in the Palmer Cravens case, the plaintiff got a judgment against the bankrupt defendant and then tried to collect it from the bankrupt defendant's insurers. The bankrupt defendant's insurer said, no full adversarial trial, we don't have to pay. And the district court said, yeah, you're right, and granted summary judgment in favor of the insurers. And it doesn't say it clearly in the court record, but it appears that the district court in this Palmer Cravens case sent them back to square one, which was, all right, you've got a claim now against the insurance carrier, but as Hamill instructs, you have to establish liability on the underlying claim and coverage. And it's difficult to understand how. Oh, I'm out of time. So,
in your view, what did the bankruptcy court mean? They say in their appellee's brief that where's the language? BJ Services is not now, never will be liable for damages covered by the policy. What happened in the bankruptcy court in your view?
I think
the bankruptcy order expressly prevents BPX from suing BJ Services for damages.
Because BJ Services was discharged. There would be no reason for
Was there an express assignment sanctioned by the bankruptcy court?
Yes. Okay. Judge Isker signed an order assigning BJ Services, our claims against BJ Services. The only way we were ever going to get any money on that
was to
was from
pursue them
insurance.
outside of bankruptcy pursuant to an assignment.
Yeah, pursue their insurance carrier.
Is that what happened here?
That's what we contend happened here.
If we go and look at the record, we'll see an express assignment of claims.
Well, the assignment is in the order. Judge Isker's order explicitly assigns the claims that BJ Services had against Underwriters to BPX.
Okay.
Thank you.